so many shrimp, I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the streets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the buck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp, I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The rest is greener on that other side. If you know what I mean, I show you shit you never seen. The 7 wonders of the world, and I can make you look if you wanna be my girl. I say my girl, I don't need my woman, that ain't my style. Need a real street stalker, walk a green mile. You piling up the paper on the dining room table, 'cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. 'Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get chose.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp, I got iodine partners.
Hello, everybody. Happy Thursday. I was almost about to say Friday. I wish it was, but no. Welcome, everybody. Welcome to round 1 of the Judicial March Madness. I'm more than confident that my NCAA tournament bracket has already been busted. I have no idea. I'll probably find out later. We got Maik over here. We got Serrana right here. Hi, baby. Look out, baby. Oh, come here. Oh, I'm so glad I can still lift you up with one hand. Yeah. Hey. Yeah. Haha. No, you're mine. You're mine now. You can't escape. 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 We are going to start the running very soon with the first round. We'll start it off with the number 1 seed, Judge Simpson, versus Manning. And then we'll be watching some highlights from both that we can find. I did get somebody to get a couple of videos lined up for some of these other judges. I didn't ask them to. I told them they didn't have to, but they did it anyway, like a mad person. Hey, nya, nya. Yeah. I can rubber belly, but she always wants to pounce and attack. But I do it anyway because I can take it, even though your claws are like little dagger needles. The same with your teeth, because you're a demon. You're so evil. Get down. I think she wants to get down. She wants to get down, right? Okay. There you go. All right. So I feel like the problem with Judge Simpson being the number 1 seed, it's like Judge Simpson has a lot of good videos out there. What I have, what's a good one for Judge Simpson? I don't know. What do you guys think? Yeah, we could do that one. Since that one went infamous. Yeah, that's one. That's the one I'm thinking. There we go. Wait, nope, no, 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 no. This is the follow up hearing. There we go. All right. And then let me get the vote, the polls set up. We're gonna reset. And we're gonna do this 20 minutes. I think I have a good idea who's gonna win this. The problem is that I was trying to think of a rule to try and like not let it be a steamroll of like the top judges into like the final four or the finale. But I couldn't think of anything that either wouldn't be too complicated or too restrictive on y'all. So I think it's just we're just gonna go for it as is. You guys can make your votes, do what you want to do, and we're gonna go from there. As always, the thing is vote. Use the command vote and the number 1 or the 16, reflecting the seed. And we're gonna go start now.
Defendant is turning himself into the Washington County Jail by 6 p.m. today.
Assistant Public Defender Natalie Tate for Mr. Harris, who should be present via Zoom.
Mr. Harris, are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
Damien, thank you for the milestone.
Hey.
And also, Lane, thank you for being the first purchase of the new merch store. Thank you very much.
You stationary?
I'm pulling in right now at this second. Yes, I am.
All right. What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. This is a driving while license suspended,
That is correct, Your Honor.
and he was just driving, and he didn't have a license.
Is with the charges, Your Honor, yes.
No, I'm looking at his
Yes.
record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Well, when we saw this, we saw it go viral like in real time. The day that this happened, we saw all the local news outlets pick this up one after the other.
Hello?
Hello.
1 minute, Mr. Harris.
I don't even know why he would do that. So defendant's bond is revoked in this matter. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
Brilliant.
Thank you.
Thank you, Your Honor. Mr. Harris, I'll be giving you a call.
Dumbass.
Court calls the case. People versus Maya Isom.
Bye.
Assistant Public Defender, Natalie Pay for Ms.
Oh, I don't know why you're still here. No, he did not have a license. Or, if I recall, is that he'd never had a license to begin with. That was the issue. He never had a license to begin with. He never actually got a driver's license.
Out to a friend of my client.
Caller.
Oh,
Court does call the
all
case of the People versus James Whitley.
Oh, I love this one. I think we remember this one.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is People's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Oh, he pissed. He mad.
Have you seen it? 14A District Court of County, Washington, session, the Honorable Judge Simpson.
You may be seated. Court recalls the case of the People versus Whitley.
Assistant Prosecuting Attorney people. Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in with on behalf of Mr. Whitley, who's standing to my right. Whitley, can you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No. My turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart
Moscow lady.
the desire just to lock your
Oppenheimer. I'm gonna just call you Oppenheimer. Can you get me a link to that video? involving Moscow Lady and Judge Manning?
Client up. Quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not by any means punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right.
He is not happy. Oh, okay. All right. Judge Manning. Custody. Let me see here. Maybe you guys can point it out for me. Let's see here. TPO case. Thing is, I've only seen a little bit of Manning's cases. NBA player's ex who kept jumping venues to get him in trouble. Oh, is this it? Oh, this it. I think this is it. I
You
think
can
this
hear
is what
what
we're talking about.
Ms. Simpson. All right, go ahead, Ms. Simpson.
Okay, so there's 3 grounds on which we're seeking dismissal of this case. I filed my motion to dismiss. I don't know if you've had a chance to read that, Judge. But okay, so the first ground is that this court lacks jurisdiction. Second, this matter has already been litigated and adjudicated twice in California. And third, my client was never properly served with a copy of the petition.
Okay, so the jurisdiction is always a really tricky thing when it comes to family court, because how do you handle jurisdiction when say the parents got divorced in Texas, but and then they adjudicated visitation in California, but then now mom and the kid are in Alabama, and they want to hold like a change in visitation, change in custody, or something like that. It could be really, really. I completely forgot how it all works, but it's really, really messy. The other thing is when she's saying that this has already been litigated, full faith and credit. Thank you for the sub, Epic Gaming.
Case.
Shout out to We Need Justice Please for supporting the channel and requesting more Fulton County, Georgia cases. I have another one today. Also,
Serrana.
thank you to Tiffany for sending in that case that we're about to get into. Tiffany said this one right here is another reason why we have to check other women. Children are not weapons. Tiffany also said the women like the one that we're about to see today, they know the games to play and have been using the system for too long. I haven't watched this one yet, so let's not waste any time. Let's go ahead and jump into it.
On the jurisdiction issue, this court lacks jurisdiction over my client in this matter because the Family Violence Act provides jurisdiction over non-residents only where the acts of family violence are alleged to have occurred in Georgia, and that's OCGA 1913-2B. My client is not a resident of Georgia. He has never been a resident of Georgia, and the petitioner has not alleged that any acts of family violence occurred in Georgia. The basis of petitioner's complaint is an alleged incident that occurred in California on February 6th. Petitioner alleges that the party's 6-year-old son returned from parenting time with his father, my client, with a bloody knot on his head. Setting aside for the moment the fact that petitioner has no evidence that my client had anything to do with the scratch on the child's head, it is undisputed that both parties and the child were in California when this incident occurred. That alone dispenses with petitioner's claim relating to the child. This court cannot issue a protective order on behalf of the child based on these allegations because this alleged incident did not occur in Georgia. Therefore, this court does not have jurisdiction as to that claim against my non-resident client. The only other allegation of family violence that the petitioner raises in her complaint is that my client allegedly threatened her life, quote, if you leave California. Again, there's no evidence that my client ever made such a threat because he didn't. But again, you don't need to decide that question, Judge. You only need to determine the threshold question of whether such a threat
Jurisdiction
would constitute an act of family violence that occurred in Georgia. And under both the Anderson and Huggins cases that are cited in our motion to dismiss, it's clear that a communication sent from another state, whether by phone or by email, does not constitute an act of family violence in Georgia. The act of placing the call or sending the email are deemed to have occurred in the state where the communication was sent. And petitioner does not allege that my client came to Georgia to make these alleged threats against her. She doesn't even allege that she was in Georgia when the threats were made, allegedly made. She claims that my client threatened her if she left California. But even if she were in Georgia, the alleged act itself did not occur here, and the court does not have jurisdiction to enter a protective order based on this allegation.
Not sure where he found his attorney from, but she did not come to play. She came out swinging right out the gate. She's
yeah, obviously, if you got a good attorney, yeah, they sound like they know what they're doing. And this attorney sounds like she knows damn well what she's doing.
trying to bring him down with lies. Now, I guess she thinks as a woman, he's supposed to take whatever licks, but Rashawn didn't come to play in this courtroom. You see, when men lose, women always say they should have fought harder. Well, men like Rashawn, who's 29 years old,
Oh my God.
they're
All right, the only reason I'm not a fan of this channel is that this channel is so obviously like pro male and like red pill esque, but they actually this Pink Book Lessons channel does have has some good videos, but man, they skew heavy. Yeah, it's Freaking Pope's right. This is an ultra pick me type channel.
doing just that.
Okay.
So in an effort to continue to get his way, I'm sorry, I had to move around because my son was in an effort to get his way, he is doing the same thing that he did in Sacramento because he just doesn't want the violence to be heard. So after March 30th, he was him and his family began attacking me in media, and we were told that it is totally okay for us to go back to our home in Georgia. We were only there on visitation purposes. After March 30th, after he lied and told the judge that he did not live in Los Angeles, we spoke to the California domestic violence advocate for the Secretary of State, and I filled out a good cause notification, and I filled out a safe at home program with which is a domestic violence program in California, in order to make sure that I lawfully came back to my home in Georgia. We were in domestic violence shelter from March 30th. I even gave him the opportunity to meet with RJ, with a mediator, to speak about the things that RJ was saying about what happened to him. He refused. He's only interested in controlling me, controlling RJ, and controlling the situation. Also, the violence has taken place here. A defects worker came to speak to RJ separately, and this is about my 6-year-old saying that he is afraid. And if that wasn't the situation, then the defects worker wouldn't have issued us a safety plan. Also, the police, the Sandy Springs Police and the Fulton County Police were contacted. I showed them those orders, and the orders from a private mediator that is privately paid on a fiduciary, in a fiduciary fashion by one party. Those are not orders by a superior court judge. That is not a superior court judge. I complained to the commissions on judicial performance, and I filled out a appellate and a motion to dissolve the stipulation. What we're in is a mediated stipulation by a hired neutral who is not supposed to be making changes to our stipulation, as you see from the letter that I received from the judicial commissions of performance. He is not a judge. He is not a member of the bench. And he is not a member, and the orders that he creates are paid orders by $2,000 an hour. The stipulation, that is the only thing that the evidence that I wasn't able to provide. This, and he is blatantly, if I've done something wrong, it's because I'm just trying to protect our son who says that he's afraid of you. He is actively lying.
Chill with that. I did notice that she said my child more than once, but then she switched to our. I'm not fully understanding what kind of argument she's making, because she's in other words, she's completely sidestepped the jurisdictional argument, unless she's trying. All I can hear from her is that she called the Fulton County Sheriff's Department or the
ordered. I'm sorry. He is actively and purposely forum shopping in order to get out of each court. He lied to the Sacramento court to say, "Oh, I don't live here," and now here he is saying, "Oh, a superior court judge." If I called the Los Angeles court, and they know nothing about these orders. This is a mediator that is a mediator to the stars. He gets paid hourly by my ex-husband in order to give his way. If he stops giving his the mediator that made these orders about abduction, and this mediator has also done all different types of unlawful practices in order to give my ex-husband his way, because he is a rich athlete that feels like everything is supposed to go their way. I have been in
okay, chill out.
Compliance with everything. We have been divorced since 2019. I have been in compliance with everything that lawfully that I was supposed to do. I would never do anything unlawful, because I don't even have the millions of dollars to fight in court. He does. What I'm saying is true and provable down to each letter with a piece of evidence. I wasn't able to provide all the evidence this morning. I was planning on doing all of that before the 13th, but to say that the violence didn't happen in Georgia, it absolutely has. He and his family members are on a line actively threatening me, showing guns, and I have text messages of him threatening my life the day that I served him. I served him.
Wait, what do you mean you served him? As a party of the suit yourself, you're unable to do that. So that means that one of the arguments the attorney made, she was correct. She just admitted that without realizing that she did. She's trying to win this with emotions, but you're dealing with the law.
It depends on, oh, well, we got our winner. No shock to anybody, Judge Simpson is the winner, but we're going to keep watching this video of Judge Manning. I think she deserves that. It depends on the state. I know in federal jurisdiction, you are not allowed to personally serve. Other states may allow personal service, but most of them don't. Most of them, they do require you to get a third party to serve somebody.
And he was served to the best of my ability. I served the document.
Now she's walking back a little bit.
That was I received after our hearing on Monday. I also checked with domestic violence advocacy here just to make sure that what I'm doing cannot be considered forum shopping, because that's not something that I would ever want to do. He is the one that now provided evidence saying that this Superior Court judge ordered, the Los Angeles Superior Court knows nothing about the orders that the mediator, Thomas Trent Lewis, has issued. Thomas Trent Lewis is not a member of the bench. And the orders that he has created, he is a neutral hired by a law firm.
So this says that Judge Lewis is retired.
He is retired. He's not a judge.
Well, so I mean, you can tell by my accent, I'm not a California lawyer, and don't think I practice law in California. Wouldn't even try to practice law in California. But I would tell you that they're retired judges and senior judges here in Georgia that would take some offense to saying that they're not real judges. So
oh no, I apologize, Judge. Definitely.
No, I just said so this
I'm speaking in terms of this case. He is not. I'm sure
thank you for
he spent
the
time on the bench.
anniversary.
He is a retired judge.
But
But
that's what I'm saying. And it looks like, but so let me kind of get you back on track. All right. If you don't mind, Ms. Simpson.
Please.
Okay. So it looks like these are orders that are signed, that have been submitted. Findings after hearing, federal custody support. They're orders that has his electronic signature, you know.
Yeah, so she basically was trying her best to minimize the prior orders.
And it looks like they were sent to a couple different lawyers.
Yes.
One of these lawyers yours. So it was on one's January the 3rd. There's another one that was April the 22nd. So tell me, what is it that you have to say about the April the 22nd? Because the way I'm reading this, you correct me if I'm wrong. Because like I said, I like to tell people, I know when I open my mouth.
No.
You gotta keep your camera on, Mr. Holmes. Hold on, wait on Mr. Holmes, because we don't know if he's there. He's got to keep his camera on, because this is akin to walking out of my courtroom when you turn your camera off.
Uh-oh.
Your Honor, I don't know what's going on with my camera. I'm still here.
Did you get a phone call? Sometimes you got to, you got to like.
No, ma'am. I went on mute and the video cut off, and I'm hitting to start the video now, and it's not starting.
All right. Does it do that if I say ask to start video? There you go.
Okay.
All right.
Thank you, ma'am.
Yeah, no, sir. That's fine. So I'm looking at this April 22nd order. Okay. Are you familiar with it?
While we're watching this video, I'm gonna get the next matchup. I don't want to do all the top tier ones all at one go. So I think this one's gonna be a bit more competitive. I actually think this is gonna be a bit more competitive. We're gonna go with 5 versus 12. 5 versus 12. So let's go with that. I'm gonna set it up.
Yes. Okay. So it's electronically signed by Judge Lewis on April 22nd. And in here, okay, so this is where I'm kind of having some, because I can call out, I don't know what time it is out there, but I can call out there. It says, let's see, I want to make sure if you got it in your hand, okay, there's a case number. You're the petitioner. Mr. Holmes is the respondent, or plaintiff and defendant. So it says, respondent shall select 3 professionals and monitors to provide said names to you. You shall then choose 3 of those professionals and monitors that you may use for your visitation. So it looks like at some point, you're supposed to have supervised visits and pay supervisors. Right? I'm sorry, he's going to pay supervisors. So this was on the 22nd.
Yes, and that was
so this was, and it's signed by Judge Lewis. Okay, so hold on, back up. Let's go back. Sorry, these are all scanned in. Let me get back to. Oh, there it is. Okay, it's marked. All right. So findings after a hearing. There was a hearing. The hearing proceeded at April the. Can we share my screen so you can see where I'm at?
No, I can see. I know what you're.
Okay. So it says it was April the 21st at 8 a.m. Good for Judge Lewis getting up there. I like it. All right. So 8 a.m. Let's see. Ms. O'Brien appeared at 8 a.m. on behalf of you. Filed the substitution of counsel because you said you wanted to. I guess that's pro se, but pro per. So you want to represent yourself. So there's modification, custody and parenting time. Here it said that sole legal and sole physical custody was awarded to Mr. Holmes.
Yes.
Well, what are you doing here? She's obviously misusing the system, wasting the court's time. She didn't like that court order that gave her supervised visits and awarded the father full custody, so she decided to use the court and these restraining orders to be able to hold the child away from him when he's the one who's supposed to have the child in his possession. At this point, it's very clear what she's doing.
And after I contacted the family, the Stanley Moss Family Court in Los Angeles, and also contacted the district attorney's office in Los Angeles, a order.
Oh, wait, you guys started the poll already? You're not supposed to do that. Stop it right now. I don't know what you guys are doing. But you were not supposed. I did not set this timer to go.
Orders that are made by a private mediator fiduciary. He cannot change our final orders. They are supposed to be a neutral, and he does not have.
This is a court order. So I mean, like I said, I wasn't there. It says this is a court order. So that was a hearing.
And that was made, and it's because, and mind you, the defendant does pay Judge Lewis. And the night before that happened, I made them aware that we were in a domestic violence shelter and how we were being treated was unfair. And I will be alerting the presiding judge that presides over this stipulation, because everything that is put in our stipulation, and if there are changes made, is supposed to go through the actual Stanley Moss Family Court. When we have Zoom court, they're similar to meetings. So that was his attempt to, the night before, I emailed them and told them that we were in a domestic violence shelter, and that I was still being threatened, because of course the defendant is not going to say what he's been doing.
The disgusting part about all of this is not only is she misusing the system, but she is also repeating DV and DV over and over again to evoke emotions. They are not together, and they haven't been together for 4 years. They divorced in 2019. So the only allegation she can make up right now is that he did something to their son. No one believes it. They see she's trying to use that as a tactic to keep the child away from the father to try to establish custody for herself. Why? Because she's got to have that child to get child support. Also, he already paid her alimony. It ran out. In California, they got the divorce within 10 years, so the alimony, it didn't last forever. All she could depend on is child support, but since he took...
Yes, because depending on the state, alimony, depending on how... alimony, well, number one, alimony is like on its way out, period, in many cases, because nowadays both parents are working and have careers. But also, in many alimony states have statutes where if the marriage doesn't last longer than 10 years, then the amount of alimony is heavily restricted. Yeah.
Took custody of the child. She's running around talking about DV so she can use that to get free housing and other assistance because she refuses to get a job. That's what this all boils down to.
And it even down to the violence that took place with our son.
Let me tell you what. So I don't know what kind of athlete he is. I don't care.
But that was his attempt.
I don't care. Famous, I'm famous. I'm a big deal. In Atlanta, I'm a big deal. Okay? So he ain't a big deal. Ain't nobody out here a big deal but me. I'm kind of a big deal. All right?
Yes. And once,
I guess he's probably tall, so he probably plays basketball. And I'm not impressed with that. I'll tell you why I'm not impressed with that, because I have played basketball longer than LeBron James, but it doesn't mean he's better than me. Okay? So bring LeBron out here and I with him too. And I played basketball longer than him. Nice. So don't mean he's better than me. Okay? So all that athlete stuff, I don't care.
And I'm glad you said that, Your Honor, because honestly, we can't act like that aspect doesn't exist, because that is one of the reasons why I'm getting threatened. And that's one of the reasons why he wants to stay in private court, because he wants the violence.
So I don't care. So don't worry about talking about money. I don't care. I don't care about that. I don't care who he is. And, I'll meet you on the basketball court at home. I'll tell you. But I'm just telling you, okay? That's it. So I don't care about it. What I care about are these allegations of violence. And like Ms. Simpson had brought up, when has Mr. Holmes been to Georgia and commit? Because here's the thing. Something has to have happened in Georgia. So when's Mr. Holmes been to Georgia? And been to Georgia and committed acts of violence?
That's the question. You're asking for a restraining order. What did he do in Georgia? Stop saying DV over and over again. Get to the facts, the date, the time, location in Georgia. And by the way, this is absolutely disgusting what this woman is trying to do. The judge here, she's been supporting women against violence for years, but you can't just automatically get support in court because you're a woman. Again, what did he do in Georgia? And the judge got jokes today, talking about playing better than NBA players. That's hilarious too. But she was right when she said stop talking about his money and status and insinuating that he's paying off judges. Just present the information, your argument, and that's how it's going to go. Not sure how this is going to end. It's already been established that she's not supposed to have the child. She's basically holding him hostage in Georgia because she doesn't want to give up her meal ticket. If you want to see part 2, let me know below in the...
I think I do want to see part 2, but we're going to move on to the next round.
All right, Missy.
And we're going to go with Judge Webster versus Judge Lenise Bryant. I know Judge Webster is definitely a fan favorite. Me personally, I've always enjoyed Judge Bryant, and so we're gonna watch this one. This is a classic from Judge Webster, and then we're going to watch. Yeah, we can watch part 2 in the later on. Oh, I almost forgot to change the title. 5th seed versus 12th seed. Save. All right, and 3, 2, 1. Poll started.
False
I
imprisonment.
want you to stop talking, or you can go upstairs to the county jail. We'll now be on being in recess on Jackson, we'll now be on the record in Johnson. That is case number 2024 TR 22, State of Kansas versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
you're charged in count 1 with speeding 82 miles per hour in a 65 mile per.
Uh-oh. What? Uh-oh. They're not registering. Oh, no. Oh, no. Hang on. Oh, shit. Shit. I thought I did change it. Yeah, I did change it. What the hell? I thought I changed the value there. Let's try it again. Try it again. Oh my gosh, what the hell? I thought I had it right. Oh, I'm upset. Come on, don't do this to me again. I had that right. Volt trigger is correct. 5 and 12. I don't understand it. Why did it work for the first round and it didn't work for the last round? Oh, this is embarrassing. This pisses me off. I'm so sorry, people. I know I fail.
Per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. And count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If in fact it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your
Now it's
record.
working. Oh my God.
If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. You have a
Hey!
choice- you have a choice of
Woo!
pleas. You can plead not guilty, and we can set this for trial at a later date. You can
We
plead
got
guilty,
it.
admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty, and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So,
Probably not eligible for diversion based on his driving record.
oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were,
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
all right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you
Your
entering a plea on
objection
my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all right,
question.
we're not going to have this debate right now. I've told
yeah.
you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would
all
like to
right,
call
I'm
the
going
state to the, I would like to call the state to the stand, Your Honor.
We're
The
not doing that,
state bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is?
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
You're supposed to act as a trustee.
Sir,
of
you
the
need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping. Missy?
Well, Your Honor, I would like to also bring to
September
according to USC 12203.
Deputy Miles,
And also
did you,
Article 3, the judge must operate in good good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be searching, illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county
boy.
jail. Now, do you want to go to jail tonight?
Your Honor, again. Title
Deputy Miles, could you come in and
USC
assist the defendant?
We're done.
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to
Your
come to
proceeding,
court.
Your Honor.
Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
No.
All right.
Serrano, that's daddy's
your first right
juice.
is to have a hearing date, and that is September 27th, 9 a.m. The second
No, I
right,
also have a right to understand the nature of this. I have a right to understand the
all
nature
right.
of
If
cause.
you don't want to listen to me, you can go to jail. Do you want to know, do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of these.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just
don't
want to
fill them
understand the
out,
nature
I'm
and
going-
cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court, September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue, does he have a bond? Looks like you do because you failed to appear on February 27th at your first appearance. So bench warrant was issued, bond was set at 1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000.
Mm-hmm. I mean,
does that sound right? You put up 1,000 cash
he's
back in July 12th.
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation.
Oh my God.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. And I'm going to have those officers escort you to make sure you do so. So, Mr. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief,
all I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is the charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of 1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
She already said it.
You're being charged under the jurisdiction of the state of Kansas under its criminal law.
According to the Constitution, there are only two jurisdictions.
All right, well, that on a later date.
There's the frog.
We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with. I'm not giving y'all a problem. I'm trying to. Well, I'm waiting on the Your Honor to explain.
All right, Missy. That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Mr. Gillette, I'll see you at 30 docket.
Yeah, there it is. Oh, no, now he wants to go home. Now he wants to go home. He had, yeah, exactly. What a dumbass.
All right, well.
Can I go home?
I left it up to them, and I left it up to you, and then they were to behave accordingly.
Yeah, moron. Yes, as far as I understand it, last I heard, after his whole South Carolina surgery, he has been hooked up by the MPs. So I think he's I think he's currently facing court-martial. All right, let's go to Ms. Bryant.
I have called your ma'am. Don't shake your head at me. Let me tell you something that I do every day, 5 days a week. I log on to this Zoom and I know how to manage my courtroom. I'm ready on McNeil.
Judge McNeil is an AG case, just to let the court know.
Ms. Peterson, the charge is trespass, and the prosecutor has informed me that that is also an attorney general's case. Can you look into this for me? And it's scheduled for pretrial today.
Yes, I can.
All right, I'm gonna recall it. Are you able to, let me know if you're gonna be able to stand in or if one of your colleagues is gonna log in.
Sure, just give me like 2 minutes.
Okay.
Thank you.
All right, thank you. I'm gonna put Ms. McNeil back in the waiting room. I mean, ma'am, don't do that. Don't do that,
Ooh,
'cause
eye
then
rolling.
I was put you last.
Oh
Don't act like
no.
it's the only case we have here today. Don't act like if you were down at 36th District Court, you wouldn't be sitting waiting. You get the opportunity to wait in the comforts of your own home. So don't do that. We don't do that. But if you have somewhere else to be, feel free to go. You have a court date this morning. You should have blocked off the morning for your court date. Good morning, Mr. Riggs.
Good morning, Judge. How are you?
I'm wonderful, thank you. How are you?
I'm good.
I'm assuming you logged in on the McNeil case?
Yes, ma'am.
All right. And then let me release Miss Peterson on the other case. That person never came back. Okay, then I am ready on McNeil and then Garner in that order. All right, this is case number 194560801, the people of the state of Michigan versus Sanita Denise McNeil. The defendant
Judge
is
Bryant's
charged
come
with
back
one
up.
count of trespass. Disassociated person, I think. Yes. And today is the date set for a pretrial. Appearances, please.
Judge, may it please the court. My name is Richmond Riggs, P33863. I am an assistant attorney general. I appear on behalf of the people of the state of Michigan.
And Ryan Murad, P83665, on behalf of Ms. Sanetta McNeil, who's present on Zoom this morning. Ms. McNeil, please unmute your device and state your name for the record, ma'am.
Sanetta McNeil.
Your full name, please.
Sanetta Denise McNeil.
Today is the date set for pretrial conference. How are we proceeding?
Judge, if I may, I don't have the file right in front of me, but I believe that the defendant is not a disassociated person. I believe this trespass charge results from prior convictions for assault with a dangerous weapon and fraudulent activity within the casino. And the Michigan Gaming Control Board served her with an exclusion notice that she was not permitted in any of the 3 Detroit casinos.
Okay.
She is not self-excluded. She is excluded by the MGCB.
Thank you, Mr. Riggs. Thank you. Okay.
Man, you got kicked out of all the Detroit area casinos.
So, Mr. Murad, how are you proceeding?
So, Your Honor, typically I make a motion for dismissal based on the complainant's failure to appear, but it sounds like there's a bit more going on here. What I'm going to ask the court.
There is no complainant. What do you mean?
Exactly. So what I'm going to ask the court to do is to adjourn the matter or maybe set it for final pretrial conference. That way, Mr. Riggs and I can maybe work something out and I can get the discovery and we can move from there.
Okay. The court will continue a not guilty plea on behalf of Ms. McNeil. And let me tell you what I found interesting. So earlier when Ms. Peterson was here and then I asked Ms. Peterson if she was able to, do the case because it was an AG case and then whatever. And then Ms. McNeil made that face and then I addressed the face and whatever. Then I didn't even realize at that time that it was scheduled at 8:35, right? So what does that mean? Right, well, we know what that means. So let me just put on the record what it means. It means that the last time it was scheduled, Ms. McNeil didn't show up. So that is so funny to me that the court did not put a warrant out for her arrest, gave her another opportunity to show up at court, and then she had the nerve to have an attitude because we were trying to figure out who the prosecutor was.
Oh no!
Ma'am, don't do that in my courtroom because it won't work out for you. It definitely will not work out for you. Additionally, I try my best to these days because I haven't always tried my best in this area to not I don't know, do whatever. But the appropriate way to sit in court is not with your arms folded like that. So that's not the appropriate way to sit in court. And then I'm gonna address bond. I'm gonna address bond at the end of it all because I keep telling people that me and my staff, we don't come to court for people. I don't know anything about what happened at that casino, right? What I'm doing here is managing a courtroom. Ms. McNeil continues to roll her eyes at me, to huff and puff at me. When I woke up this morning, tired because I am still drained, right? When I woke up this morning tired, I did not wake up and say, oh, I'm so excited to go to work so that people can roll their eyes at me, smack their lips at me, and treat me as if I arrested them, charged them, and now am presiding over their cases. I come to this job and I try to do my best in this courtroom. But what I won't do is have people who vest in this courtroom. But what I won't do is have people who have their own issues come here and bring their issues to me. You have smacked your lips at me several times. You have rolled your eyes at me several times. And the thing of it is, I grew up.
Click their tongue. Whatever.
Up at 6115 Seneca on the east side of Detroit. I am the queen of eye rolling, the queen of lip smacking, and I'm the queen of some other stuff that my job constrains me from. So let's not go there with me.
Hey,
because I have
David.
tried my level best
Doing okay.
to not only, okay, I have tried my level best, but if you roll your eyes at me one more time or smack your lips at me one more time, I am going to revoke your bond, and then we can manage this case while you're in the Wayne County Jail. Don't do that again. You're being rude and disrespectful, and I have not done anything to you. I have not done anything to you. So if you choose not to come to court appropriately on Zoom, if you have a problem with me saying that you're not supposed to be linked up on the table with your arms folded, let's just come in court in person and you can stand up at that podium. And then I wouldn't have to worry about you leaning in on that table with your arms folded.
Your Honor, with respect, I'm not even rolling my eyes at you, not even being disrespectful at all at
I
you.
want you to, that's not how it works. So I don't know what that means, Your Honor, with respect.
Yeah. Anytime you start with all due respect, it you can just dismiss everything that's going to be said as though it's going to be serious.
But also, if you have something that you want to say, ask if it's okay for you to speak, and then wait to be acknowledged. All right, Mr. Murad, how are we proceeding today? Because as I said, I'm the queen of eye rolling. I know when people are rolling their eyes at me. And I also know I can look at you and see your lips smacking. But here's the thing, we're live on YouTube. That video is still going to be on YouTube. So you, after this court appearance, can go back on YouTube and watch it for yourself. Mr. Murad, I apologize. How are we proceeding?
So, Your Honor,
Gardner.
we're asking the court to have the matter set for a final pretrial conference for the purpose of Mr. Riggs providing discovery and hopefully us talking about a potential resolution.
Court is going to set the matter for a final pretrial conference, August the 24th, 2022 at 9.
And we got a winner of Judge Webster. This one at least was a bit more competitive than the prior one.
9 o'clock a.m. Discovery should be submitted to the defense by July.
My bracket has been broken. No, not really. I figured if Judge Bryant made it, she'd probably lose in the next round.
The 25th, 2022. Bond will continue with absolutely no contact with any Michigan casino. I'm sorry, Detroit. You said.
Oh my God! I didn't realize that the gap closed. Oh wow, she lost by three votes. Okay, this was super competitive.
She's banned from the Detroit casinos. Okay, so no contact with any Detroit casino. That's the MGM Grand. The I don't even know the casinos anymore.
Greektown,
Motor City, and Greektown and Motor City. Thank you. Oh yeah, Greektown, Motor City, and MGM. No contact with those casinos.
Were we supposed to have thunderstorms tonight? Because that was a loud one. Oh boy.
Anything further?
Nothing on behalf of the people, Judge.
And Your Honor, just briefly, I want to take an opportunity to apologize on behalf of Ms. McNeil and take responsibility for some of this. When I talked to Ms. McNeil in the breakout room, me seeing this at 8:35, seeing a trespass matter, I was under the impression that if a complaining witness wasn't present here, it would be a dismissal. So Ms. McNeil and I really were discussing that course of action. And I think, when she heard the record, she was a bit surprised and maybe exhibited some facial reactions that she shouldn't have. I'd like to take full responsibility for that, Judge. I'm going to talk to Ms. McNeil. We're going to get that together, and that shouldn't ever happen again.
I started putting up this, I started putting this up right here. You all know what I put up. I started putting this up right here when the people were, playing and,
Oh no, she caught on.
The court videos on YouTube and, putting them on their channel and everything. And I started putting up this right here. the judge that is presiding over the, I'm having brain freezes this morning. Johnny Depp, is that his name? Yeah, Johnny Depp and her, the judge that's presiding over that trial, they don't put anything up like this on their screen. So it's being, like, and so do you know there are like hundreds of memes out and TikToks, it could be thousands, I don't know, of those facial expressions and whatnot that they make in court. Facial expressions are something, right? They're something. And whether or not Ms. McNeil was surprised about that it wasn't going to be dismissed, because certainly I would hope that you would have said it's possible that it could be dismissed, or it's most likely to be dismissed. I would hope that you would have said, but the judge could do whatever she want to do, because the judge can do whatever she want to do, right? So even if that complainant didn't come, the judge can do whatever she want to do within the bounds of the law. That's why when we take a plea, I say, has anybody threatened you or promised you anything? That's why when I take a waiver, I say, has anybody threatened you or promised you anything? Because nobody can promise anybody what I'm going to do, because I'm the only one know what I'm going to do. I'm the only one. So nonetheless, she still shouldn't have been smacking her lips and rolling her eyes, no matter what she was smacking her lips at and rolling her eyes at. Because this is the judicial process, and it is to be reverenced. I know that there's a lot of Zoom courtrooms that make a mockery out of this judicial process, but let me tell you what courtroom is not going to ever make a mockery out of this judicial process, and it is Judge Bryant in courtroom 339. I appreciate that, Mr. Murad, because I was not aware that it was not a disassociated person's case either, or, the trespass usually is a private citizen. Like, that's usually a private citizen. And so sometimes it doesn't work out that way. Nonetheless, I accept your apology on behalf of your client. And of course, we all know that I won't even remember it the next time. All right. Anything further?
Nothing on behalf of the people, Judge.
Nothing further. Thanks again, Judge.
All right. You're welcome. And you're all set. Have a great day. Thank you for logging in, Mr. Riggs. Appreciate it.
Thank you, Judge. Stay safe.
All right. You as well. Miss Neal, remove the hat. Miss Neal, we have been waiting on you all day.
I've been on here.
Miss Neal, stop. Don't interrupt me. Do not interrupt me. First of all, get off that bed, and we don't want to see your legs.
Yes, ma'am. I'm sorry.
Second of all, you came in for a minute this morning, and then you have been gone all day.
I've been on here.
Miss Neal.
I'm sorry. Please don't do me like that. I'm sorry.
Please don't do me like that. Oh, don't say it like that.
Miss Neal, you have been gone all day. I have called your, ma'am, don't shake your head at me.
Let me tell you
like, don't do that. Every day, 5 days a week. I log onto this room and I know how to manage my courtroom. I see everyone who is in the waiting room. I see them when they come in and I see them when they go out. You were in the waiting room briefly this morning. I have called your case, I don't know how many times, and you have not been here. Everyone who was in the waiting room has already been to the breakout room, has already spoken to the lawyers. I have finished my docket with the exception of 2 cases, and I am getting ready to start a trial. So do not tell me that you have been in my waiting room. You have not. I have asked on numerous occasions, where's Ms. Neal? She was here for a minute. She's not here. The prosecutor who was on your case has been dismissed since 10:15. They've been gone since 10:15. Why? Because Ms. Neal was not here. Mr. Murad, I am going to send Ms. Neal to a breakout room. However, the prosecutor is gone. We will not be handling Ms. Neal's case today, and she's in danger of having her bond increased. So you all talk, no ma'am, don't lean up on that counter like that, no ma'am.
Ms. Neal, just sit back.
No, ma'am. Stand back up, and Mr. Murad has muted you because he's trying to prevent you from going to jail. So let's listen to this. Mr. Murad has muted you. We cannot hear what you're saying. Now, he muted you because he's trying to prevent you from going to jail. But let me be clear about this right here. I am Judge Lanice Bryant. Whatever you have to say to me, you better change your tone and change your facial expressions. Whatever you have to say to me, whatever you think you have to say to me, you better change your tone and change your facial expressions. Because of the people that are on this screen, there's only one that's in danger of going to jail, and that would be you. Number two, when I put you in the breakout room, please take that opportunity to go change your shirt. White t-shirts are not allowed in court. Ma'am, I'm not gonna do this.
Judge, can I just do a quick breakout room with her? I think
Oh my God.
I'm not gonna do it. She's gonna stand back too far, and we're gonna see those shorts that she also has on, which are not appropriate for court. However, since we're on Zoom, as long as she's appropriate from the top up, then we don't care about the fact that she has on shorts for court because it's on Zoom. So I'll put her in a breakout room. I clearly see that she's in need of one. And when you go into the breakout room, please explain to Miss Neal who Judge Bryant is.
My goodness.
I'm ready on price before you go deal with Miss Neal. I'm ready for the people who came to court and stayed in court appropriately.
Yes, Your Honor.
All right, this is case number 07659.
Wow.
1101.
Put something on.
The people versus Terica April. January, maybe. Neal, defendant is charged with one count of gambling. Today was the date set for a pretrial conference. Appearance, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Terica Neal. Ms. Neal, ma'am, please unmute and tell the judge your full name.
Terica April Janae Neal.
Today was the date set for pretrial. The prosecutor was present. The prosecutor was released at 10 o'clock. As I previously stated, Ms. Neal was present for a minute and left and came back at the end of the docket. Court is going to adjourn the matter. What day am I giving? Judge, we are at today, July 6th. July 6th. Same time. What time is it? 8:25. Be on time and stay.
Yes, ma'am. Thank you.
Thank you.
All right. We got the next poll. Ready? Oh, almost ready. Hang on.
The Trump administration's standoff with the judiciary continues.
Nope, shut up. This is not politics. Third seed versus 14th. Judge Darrow versus Judge Rick. And I think I have... Oh, man. Judge Rick has so many good ones, too. Oh, man. All right, I like this one. I like this one. It's short and sweet. But as you know, Judge Darrow blessed us with the Dale Brooks trial. I thought she did ultimately a fantastic job, but we're going to start here, and the polls are going to be open in 3, 2, 1. Hopefully it works the first time. And starting now. Yay! It works the first time. Perfect.
Okay, why is there a Juan Flores on this meeting?
Hello, Juan.
There's no response. Okay, whoever is Juan Flores's box is muted, so I'm not hearing anything. They can unmute themselves if they've got some business with this court.
Hi, Judge. I am Counselor Flores, and I am resident McLaughlin's counselor, and they have him here right now.
Okay, very good. Thank you.
Yep.
Jesse Travis McLaughlin.
Yeah.
This is State of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
Okay, I was actually not expecting this poll to be this close. I'm actually surprised. Damn. All right, I appreciate that.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance of
speak for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order.
Point of order.
What gives you jurisdiction to appoint a lawyer over me?
Ooh.
I have statutory authority to do so.
You want uppies? You want uppies?
So, Mr.
So
Kaufman,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's
Yes,
made a
Greg.
request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order.
Thank
As
you
a
for the
first
That's
$5
all
super
the
chat.
points of order that I'm
First
inclined to
thing you
address
must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection
Okay.
noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy of- I
Thank
request
you
a
to the
copy of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time. All right, Virgil Fry.
All right, let's go to this
All right,
one.
thank you. The jury can come on out.
Oh, wait. Wait, hold on. This is the perfect time to showcase this.
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to by what's the last guy? Goose.
For those of you who don't know, there is this random channel called Linus Wallace. I'm going to share this video in the chat. And this dude decided to make South Park animations of various parts of this of the Darryl Brooks trial. Why? I have no idea, but it's freaking awesome. There's a link.
That he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you
Sir, do you want to open up the door to the other act's evidence of
That's not opening.
No.
That's not
Hear me
opening the
out.
door.
Sometimes in a court of
Yes,
law,
he
when
has the
pretrial
fort.
hearings, the testimony
Wait, do you want to? Okay, you know, let's go with the box fort. Fine.
Madam Clerk, may I please get verification that the audio and video are working in the neighboring courtroom?
No, that was someone else, Link.
All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. I'm not asking for a response yet, Mr. Brooks.
Objection!
What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. Do you have any requests as it relates to the jury instructions, sir? I would note he put two boxes right in front of where he's seated, so I can't presently see his face. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we
Yes, I
can
think that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Hey, why are you telling them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you.
Jake, she did not win her election with it, which I think is absolutely criminal. She did not win her election to the Wisconsin Supreme Court, and I think that's very disappointing.
A third time, do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests as it relates to the jury instructions? Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is it?
Yeah, I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little sir. Now it's all this sir and all this. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree.
I'm having a brain fart. What did Brooks do? Brooks is responsible for the Christmas parade massacre that happened in Wisconsin in 2020 or 2021. I think it was 2021. Yeah, 2021.
Agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order. So we'll come back at 1 o'clock to finalize the verdicts.
Yeah, he's got a lot. A lot of these. Not the secret plan of Daryl Brooks. Derail the trial as much as possible? Question mark. Not guilty.
To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without any basis in law or fact.
It's obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people getting on the stand?
You're assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask questions to lay a foundation
all of a sudden the state
with these
don't
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part, sir. It is pure commentary
I just want that on the record. I see through it. I find that very.
I'm having the jury brought out. I'm instructing you to avoid the commentary when the jury comes out, or you will forfeit your right to be present.
Before we
do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one ear that work, and I heard that.
This is to benefit you so that you
not.
understand
Ain't none of
your
this to benefit me, so let's
has
be clear
a prior
about that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice.
So can
Your
you
Honor,
tell,
I
can you
believe he
please?
has 7 prior convictions via OWI second from 2006.
Right, I need to take a break. This man right now is having a stare down.
Yeah. I remember that. This is where he was mean mugging her. He was mean mugging the judge. Crazy.
With me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Yeah, I remember that. I remember that part. Let me see here.
Do I actually have Judge Webster on this meeting with us?
Yes.
Okay.
Yes.
Wait, what?
All right. Judge Webster, other than the case, are you intending to handle the remainder of this docket?
Yes, I was intending to handle the case too. Have I been endorsed as a witness or something of that sort?
Ms. Gillette, can you answer?
I was not expecting this crossover episode. What the hell?
I believe you'll be endorsed as a witness just in case, because it all happened when you were on the video. So I wasn't on the video yet, so I didn't hear any of it, but we've obtained the video.
Okay, so you're going to do the co-hearing, Judge Ricky?
I am.
All right, very well. Wanna go-
Would it be all right with you, Judge Webster, if I went ahead and took that case up first?
Yes, most definitely.
All right, if we could go ahead and have Mr. Coe seated at the jail Zoom location, I presume that's where he's at. All right. Be just a moment. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Bobby Joe Coe. It is case number 2020.
His name is Baba Joe. Oh, wow.
4 CR 174.
Shocked this ain't in Alabama.
Appears as Greenwood County attorney. Bobby Joe Coe appears from the Greenwood County Jail Zoom location. This matter comes before the court at this time for first appearance. Mr. Coe, do you have a copy of your charging document before you?
No, sir, I sure don't.
Then I will inform you that in count 1, you are currently charged with criminal threat, a level 9 person felony.
Oh, so he okay, now I understand based on the comments in the video. So this dude, I think we did watch that one. He threatened Judge Webster. And so now Judge Rick or Ricky, whatever. Judge Ricky is presiding over that case and Judge Webster is the witness.
Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge. Missy, I'm going to go ahead and keep this case. So the next setting will be before me. Let's get a setting on my next docket. I'm currently contemplating Thursday, October the 3rd. I have my assistant on this meeting with us. I'm sure she'll intervene. As far as I know, I could do this at 9:30 a.m. that day. Mandy, can you confirm that?
Yes, that's still open, Judge.
Thank you. October 3, 9:30 a.m., what's generally referred to as a preliminary hearing control setting. Mr. Coe, you will need a full.
Okay, now this is March Madness. I was not expecting Judge Darrow to win. I fully expect Judge Ricky to win this. I'm shocked. This is a March Madness-esque upset victory for Judge Darrow.
Fully participate at that time.
Yes, Your Honor.
October 3, 9:30. All right, Mr. Coe, do you have the financial resources to hire your own lawyer?
No, sir.
Okay. Do you have other cases pending at this time?
I fully expect the Judge Ricky to win.
Your Honor, I do.
Okay, who's your attorney in those cases?
William McLennan.
Okay. I will appoint him in this case as well. William McClendon is appointed as counsel for Bobby Joe Coe. What recommendation do you make regarding bond here, Ms. Gillette?
Judge, I would ask the court to set the bond at, Mr. Coe's been in there a while, but he's got some other issues that are not related to this case. So I'm gonna say,
All right, I'm gonna let this keep on playing while I'm picking the last matchup for the evening.
1,500 cash or professional surety.
All right, so he has other holds on him currently?
He's got other cases that he's dealing with also.
All right, I believe that's a fair amount, and the court will adopt the prosecutor's recommendation and set bond here at $1,500, cash or a professional surety required. You'll need to stay out of trouble while you're out on bond, Mr. Coe, obviously.
Yes, Your Honor.
Have no contact with the alleged victim in your case, and you'll need to make sure you appear on time for all scheduled court appearances in the future.
Yes, Your Honor.
Furthermore, I think I'm going to require you on this court's next appearance on October 3rd that you appear at the Greenwood County Courthouse in Eureka, Kansas for your next appearance. I don't want you appearing remotely from any other location.
Yes,
You'll
Your
appear
Honor.
from the courthouse location, okay?
Yes, sir.
Any questions about any of this, Mr. Coe?
No, sir.
Ms. Gillette, anything further we need to address regarding the Coe case?
No, Your Honor.
Very well, then I will allow Judge Webster to go ahead and meeting at this time, as may Mr. Coe.
Judge, I have a question.
Yes?
So the victim, who is that? So I know if he bonds, what to put on the bond sheet.
The listed victim is Deputy Fisher.
Okay, all right, thank you.
Is that what the charging document says?
The charging document says a Monty Hunter, Ms. Gillette.
Shouldn't. There's an amended complaint, Judge.
All right, let's go
Okay.
with
It says Deputy Fisher in the amended complaint.
Then Deputy Fisher apparently will be the alleged victim, Mr. Coe. I don't want any confusion here.
All
right,
All
thank you.
refresh.
Very well then. I will leave the meeting at this time. Thank you, Judge Webster.
And thank you, Judge Ricky. All right, who is at the jail, please?
All right, Ricky is bumped. I actually cannot believe that he got bumped out. Damn. All right, I have one ready and waiting. We're gonna let this Webster play out while I set up the poll.
Say your name.
Alex Brown.
Mr. Brown, good afternoon.
How are you doing?
I'm okay. We're on the record in 2024 CR 172, State of Kansas versus Alex Brown. Mr. Brown, in count one, you're charged with unlawful possession of the controlled substance methamphetamine and or MDMA. This is a level 5 drug felony. The penalty ranges from 10 to 42 months, depending on your criminal history, if any, and the maximum fine could be up to $100,000. In count two, you're charged with unlawful possession of the controlled substance marijuana and or THC. This is a Class B non-person misdemeanor. The penalties are $1,000 maximum and up to 6 months in the Greenwood County Jail where you are now. In count three, you're charged with unlawful possession of drug paraphernalia, specifically a grinder, pipe, plastic baggie, with the purpose of either storing or containing, concealing.
Oh my God, he does look like a dude out of an Oblivion character creation. Like the head shape is perfect.
Ingesting, or inhaling, or otherwise introducing a controlled substance into the human body. This charge is a Class B non-person misdemeanor. The penalty could be up to $1,000 and another 6 months in the county jail. In count four, you're accused of theft of various food items, totaling about $2,500 with the intent to deprive Family Dollar store of the possession, use, or benefit of the
Family
property.
Dollar. How dare they?
And as charged, this is a Class A non-person misdemeanor. The penalties are a maximum $2,500 fine and 1 year in the county jail. Now, this felony charge entitles you to a preliminary hearing. And that
Okay. How do you steal $2,500 from a dollar store? Well, it's Family Dollar, so I can see it. Considering I frequent my local Family Dollar for stuff all the time. You could. You could. It's gonna be a big ass cart, but you could.
next date, Missy, for a preliminary hearing?
All right.
I
This
didn't
one.
have to agree to anything because I.
This is Judge John Stevens from Texas versus Judge DeSanto of, I forget where she's out of. I feel like this is going to be another close one. Michigan? Yeah, I think it was Michigan. So we're going to start with Judge Stevens. Ugh, sorry. Goodness. My personal pick, I would pick Judge Stevens. But we can go. In 3, 2, 1.
You didn't have to agree to anything because my order
Polls are
obligates
open.
You don't have to. This isn't a contract, buddy.
Zachariah Atterbury. So we said defendant's GPS is deactivated due to failure to pay or report. Okay, that's what we got here, dated November 22nd, 2 weeks ago.
Vote
which is
7 for Stevens,
a mortal
10 for
sin.
DeSanto.
Really? Really? I mean, so what is the status of the device?
On my ankle still, it gets charged every night. This is the first of my knowledge that was deactivated.
It says to pay or report. I mean,
I
that
didn't know
shouldn't,
it's for
that shouldn't be, hold on. I mean, that's what the court notes are. He is behind, he owes $1,125. We're going to deactivate him for failure to make payments on his device. That was on 10/14, so it's going on now 2 months. You've been put on notice, sir. And it's, huh?
I didn't mean to interrupt you.
What were you gonna say?
Like I said, I haven't received a notice or anything.
You don't have to have a notice. You have to pay, and it says you're $1,125 behind.
Like I said,
is that right or wrong?
I don't know. Because
well, if you don't, that's not the right answer for someone who is obligated to make payments. I don't know is not, you ought to have records and they need to be produced because your burden is to prove otherwise.
I think
it's not mine.
I think the clarification, Judge, is that the complainant in this case.
Also, by the way, shameless plug, merch store is open. Link in the description. I have decent t-shirts, a hoodie, and sweatpants or a jogger, whatever the hell they're calling it. More merch is coming out soon, I promise. So check it out.
I'm looking at the probable cause affidavit and the affidavit in the indictment. I think it's Sarah Edwards.
Okay.
Well, hold on, follow me. Sarah
Oh my God, it's a
Edwards,
dead
to
heat.
my understanding from talking to him, was paying all of the fees and then she stopped paying the fees. So then he was in a situation where he couldn't afford it anymore. But she was.
That's the worst. That's the worst story I've heard.
No, this is just a true story. If I could.
It might be true, but the victim, you were indicted. The victim, you think ought to be paying for your obligations on the GPS device. Am I correct in that thing?
That's why I'm gonna tell you the whole story. The GPS device is from the misdemeanor charge that was before the felony. So to bond out on the misdemeanor charge before the felony.
I ordered a GPS device, didn't I?
And I already had one on when you ordered it.
Yeah, so it's ordered on behalf of me, too. You got two orders that you've got to follow.
And and they let me out of jail because I already had one on. So I didn't have to sign for your order, or I didn't have to agree to anything because I've already had one
You
on.
didn't have to agree to anything because my order obligates you. You don't have to.
My
It's in the
orders are my
contract,
order.
I didn't know
buddy.
who to go to. I didn't know who to go to.
You got a lawyer. You went to law school. Don't
But
ask.
he
Don't
wasn't
say
my
you're.
lawyer at the time of the GPS, but if making payment is fine, I can make retribute. I can
Oh,
pay
will
all
you
right
do
now.
that as a favor for us?
I mean, I'm not trying to be rude, Your Honor.
No, yeah, you are. You are. You have an obligation as bond. And let me tell you what I do in all occasions like this. You go to jail. Now, good luck trying to figure that out, how you're going to pay for that. But what's his orders on? My orders, please. No, an order is an order by the court, and I'm sure they wouldn't have sent this to me if I didn't. Wouldn't have ordered it, but and they sent it to your attorney here back a few weeks ago.
And I didn't hear anything from my attorney, Your Honor, or I would have paid it. I can pay it full today.
Look, no, here's the deal.
Oh, okay. This guy. Oh my God. Who's the infamous abusive asshole? Was it Michael? Was it Michael McDonald? So he's like a guy who's very, very soft spoken when trying to sell his bullshit. That's what this guy reminds me of. That's who he reminds me of.
No one needs to tell you you have to pay or you're behind. You were told up front, and you made it. That's what you. Is that what you do? Is you interrupt people all day long? I guess that's the environment you've found yourself in. Is you're the bully of the group. See, you keep saying that. You keep interrupting. You're the bully in the group. When the court talks, I get to talk first, and then you have a fair opportunity to answer. She has to take down everything that's said. When two people are speaking over each other, she can't do her job. And actually, the Supreme Court says she's really the most important person in this room, because if they don't have everything that's being heard, then they can't make rulings if there's an appeal of an issue. So let's do. But I'm not telling you anything that you and I didn't learn when we were 4 and 5 years old. And that's don't interrupt.
I forgot to make the
when they're
apron. I'm
supposed to
sorry.
be talking. Okay.
I got to do that tomorrow.
The bond conditions are no contact or communication with the victim and must have a GPS monitoring device.
That's my bond conditions. What was the date on there?
He made bond on December 29th, 2023.
Yeah. When was my bond condition ordered?
It doesn't give a date, Judge, under the conditions. It's likely when we set the bond, probably
A long time ago.
probably when he was indicted is when we set the bond conditions.
So ignorance is not an excuse. You were told, you were ordered by this court, and your bondsman informed you. Your attorney also knows about it. So
and like I say, Judge, I'm not saying that that's an excuse, but this way it's happening is that Sarah's the component, and she stopped paying. Then after she stopped paying,
that's the silliest thing I ever heard. Your excuse to me for not paying the obligation. I didn't order Sarah, the complainant, the victim. I ordered you, the defendant. I really can't do much about or Sarah. She's not before me. You are, but I ordered you to the GPS device. And your explanation and excuse to me is that the victim in this case, who was not ordered by me, you were, the victim didn't pay for your obligation of the GPS device. So it's not your fault. Silliest thing I ever heard.
Dumbass.
This is like we're in 4th grade now. 3rd grade, 1st grade. This is foolish and silly, and it's irresponsible. And you are grown up. I know you've been around. You're 1990. So what are you in your 30s here? Yeah. So you're an adult. You've been an adult for half of your life. Well, this is a responsibility that is yours an obligation that is yours. And Sarah Edwards, who you feel like this is, I hope this goes to trial so we can explain this to the jury so that the jury listens to.
God. Guys, we're in a dead heat right now with 11 minutes, 30 seconds remaining.
The person that the grand jury indicted you for hurting, and their grand jury states you intentionally, knowingly, or recklessly caused bodily injury by stabbing and cutting her about the head and body with scissors. And that that person who is alleged to have been stabbed and cut by scissors and brings you before the court, your story to them is going to be like, I'm sure to me, that she's the one that should be paying the GPS device, not for me.
Huh.
And that's my excuse. She's paid it before for whatever reason, but I didn't order her. I ordered you. And the victim not paying for your responsibilities doesn't go 1 inch. It makes me angry. I think it would make anybody, any judge, angry. But the court's orders are the court's orders. You failed to honor them. I can hold you in contempt, put you in jail for 180 days.
Ooh.
Plus, when you get out, you're not going to get out until you have a GPS device that's paid for.
Ooh.
God.
Can I just say,
Let me ask you this. You're 35 years of age. Personal question. Do you work? Are you employed?
I'm actually been employed 2 jobs recently, at Williams Brothers Construction, driving end dump and belly dump trucks. My background came back with the pending charges and the GPS monitor. They had to let me go, as well as Martin Marietta. I worked there doing ready mix trucks for 3 weeks, and then that was hired on contingency. And then when I guess it was time for me to get my own truck, the background came back, and again, the pending charges.
Yeah. You might be surprised to know that the people on bond all have pending charges, criminal cases in this court. There's 5,000 of the people between this lady next door and me, the 2 criminal district judges. They never have this problem. And this is a first in my years as a judge and as a lawyer that you need to cut me some slack, Judge, because the victim was supposed to be paying for my GPS device that you ordered me to have, not me. And it wasn't my obligation or my excuse for not paying it for it's behind is that she didn't pay for it. Sorry, that doesn't work. What else?
Just to say, first, I want to apologize for the interrupting. I'm just really nervous right now. Really been trying to get my life on track and do everything right. That's why I'm really scared to go to jail, because I am in the process of looking for a job and everything. As far as taking on the responsibilities, like you said, I'm sure you can tell by my past that I'm not too good at that. And right now,
I don't know much about your past, so really I don't. The indictment just says one thing. What you're charged with here is this.
You'd see my full arrest.
Hold on, with this aggravated assault. I don't know what your arrest situation is, and quite frankly, I'm not really interested in it. I am interested in convictions because I'm funny about the presumption of innocence. I'm going to stand by that. You can be arrested, and period. But you've been charged here with now bond conditions, and these conditions have to be followed. And failure is not an option, and that's for everybody. Failure is not an option because the other alternative is sit it out in jail until we can resolve this. But here's another thing: is you're not supposed to even have contact with Sarah Edwards. Oh, but how do you work without any contact with her? How do you work her paying for your bills? How does that work?
Because I said I have
Play like I don't have 3 degrees and a doctorate. Play like I don't have that. I don't understand how that works in your world.
I have a misdemeanor charge.
I should have posted this one because I remember this one with Judge Stevens, where he puts this lady in her place, where she makes up so many excuses for her bullshit.
The $200 DNA fee and a bids application fee of $100. Attorney fees are waived, as the court will also be ordering this defendant to pay $1,305.44 in restitution to the victims in the case.
Oh, I'm sorry. Damn it. This is Ricky. I'm sorry. I don't know why I keep getting Ricky and Stevens mixed up. But I should have shown Ricky this one. Because Ricky puts this lady in her place because she preyed on the elderly. I think that's what it was. And then she tried her best to get her to use her grandkids as a shield, which was also gross. Let me see here.
Do not address Mr. Howard.
Excuse
Do
me?
not address Mr. Howard. State of Michigan versus Perry Howard, 211444. Mr. Westmoreland's present, Mr. Kazak's present, Ms. Pinkston's present, Mr. Howard's present. Ms. Pinkston, can you sit somewhere other than your bed, please?
Pardon me?
Can you please sit somewhere else other than your bed?
Can I sit where?
Somewhere other than your bed. All right, thank you. Okay, and so where we left off last time in April was that Ms. Pinkston was indicating that the entire amount that was requested for the repairs, that entire amount was of damage was caused by Mr. Howard. Is that
yes
where we left off?
That's correct, Your Honor.
Okay.
Ms. Pinkston, thank you for coming here today. I'm back on the 30th of October of 2020. You indicated that Mr. Perry had come over to your apartment and had caused some damage to your vehicle. Is that correct?
No, I came over to his to get my belongings and my keys to my home. In the midst of that, he was enraged. It looked like he's been drinking. He pounded on my glass door of my window on the passenger side. He jarred the doorknob several times, multiple times, before he kicked the door.
All right. And when he kicked the door, did that leave some damage on the door of the vehicle?
Yes, it did. It left his footprint, his boot print that he had on, that he was wearing at the time.
Boot print.
I took pictures of it, submitted to the officer, the sergeant that was on duty at the time. And in the midst of that Monday morning, I took my vehicle to Feldman Chevrolet to get an estimate of what the damages will be, and that's what they gave me. I submitted them to the court. After that, court proceedings were still in limbo because of COVID and everything as far as that. And then once the prosecuting attorney reached out to me and told me I had to get it fixed in order to get restitution.
And so now you indicated that he kicked your door. Is that your driver's side door?
No, the passenger side. Everything was done on the passenger side.
Did he kick or strike any other portion of your vehicle at all?
The window on the same side, and he jarred the door handle several times. He pounded on the glass several times before he kicked the door. He intentionally did it deliberately.
And was the only damage done by Mr. Howard with regard to your vehicle the front passenger door?
Yeah, everything that he previously done before that, before he kicked it, yes. And I had no damages to my vehicle before he did what he did.
I object.
Now, in
Mr. Howard, you have an attorney that can object for you.
Oh, okay, I'm sorry.
Now, you indicated that you went to the Feldman Chevrolet in Livonia and got an estimate for the repairs. Is that right?
Correct.
Now, there were some in the estimate that you provided to the court, there were some repairs that were indicated in the report that included the rear door and the fender.
Well, like I said, I'm not an auto body mechanic. All I know is what the damage they did.
Ms. Pinkston, please let Mr. Kizek finish the question before you start answering, because my court recorder can't take two things out at the same time. Okay, so please let him finish the question before you start answering.
And so do you know what those the fender and the rear door repairs were specifically for with regard to damage were specifically for or not?
From my estimate and from my knowledge, they had to take the whole door panel off and replace all of that from the damage that he did.
And you've indicated that you had no other damage to your vehicle prior to Mr. Howard kicking in your door. Is that right?
That is absolutely 100% correct.
Your Honor, I don't have any further questions this time.
Hey, and winner is Judge Stevens for the win. Fletcher Boy, thank you for the $9.99 super chat. As the final winner of today's round of games. So, to recap, the winners of tonight is Judge Simpson, the #1 seed. Judge Webster, the #12 seed. Judge Darrow, the 14th seed. And Judge Stevens, the #7 seed. So congratulations to them. Tomorrow we will have the other 4 matchups. It should be fun. Should be exciting. Honestly, I'm actually shocked. I'm still shocked that Ricky lost at the #3 seed. I thought that Ricky would have prevailed over Judge Darrow's viral popularity, to be perfectly honest.
Just for clarification, what door did Mr. Howard kick?
It was the front passenger door.
And how many times did he kick the door?
He only kicked the door once.
Do you recall what type of shoe he was wearing that day?
He had an ankle boot on. Brown leather ankle boot.
Is it like a work boot or a dress
No,
shoe?
no, it's a dress boot.
So you're saying that he just kicked the front passenger door one time? He never kicked the fender or the rear door?
He dented it pretty bad. So before that, he had jarred the window and the door handle.
Correct, but he just kicked the front passenger door. That was the only place he kicked?
Yes, with a strong, heavy kick.
No other questions, Judge.
Any other witnesses that you plan on calling, Mr. Kizek?
No, Your Honor. We have no further witnesses.
Any witnesses you'd like to call, Mr. Westmoreland?
I don't believe so at this time.
I have a question, Ms. Kingston, about how long did this interaction last?
For about 20 minutes before he chased me down Biddle. So prior for that, I should have been charging assault charges as far as fearing for my life, but I didn't. All I want him to do is pay for the damage he done to my car.
Yeah, Ms. Kingston, please answer the question I've asked.
About 20 minutes.
All right, and where did, when you took the photos that were of the damage, where were you?
Where was I?
Yeah.
After I wind up losing him, I regained myself, went over one of my girlfriend's house to collect my thoughts.
Ms. Pinkston,
Over
Ms.
a
Pinkston,
friend's house.
please answer, Ms. Pinkston,
Over
please
a
answer my
friend.
question.
Over a
Please
friend's house.
answer, excuse me, please answer the question I've asked specifically without extra information. So you went to a friend's house to take these photographs?
Yes.
Did anybody else take any photographs? Any detectives or officers?
Yes.
And there wasn't any damage done to your vehicle prior to Mr. Howard kicking it?
Correct.
And how much time after you took your photographs did the detective take photographs or an officer take photographs?
Probably no more than a half an hour later, 45 minutes later.
Well, what we had adjourned this matter for was so somebody from the dealership would come in and testify because, number one, as relates to the invoice, there's stuff on here regarding a fender and whatnot, but there hasn't been any testimony regarding any damage to the fender. And so I don't know why that would have been why that would have been repaired. And second, and the photograph that Ms. Pinkston took, which looks like it's shown, there's a picture of her, like a screenshot of some sort, because it shows it like from her phone. There's a boot print, but then the photograph taken from the officer that was emailed to Ms. Shaw of our probation department does not show a boot print. And I really would like to know from the repair individual how a kick would cause the door to not close all the way when the kick was in the middle of the door.
Well, can I answer that? He ajarred my door handle before he kicked the door.
I see the door handle, but I'm wondering with the door itself, are you indicating the door handle will not, because the door handle stuck out, it will not permit the door to close all the way?
I'm not an auto body mechanic. I have no idea. All I know is what I saw, what he did.
Right, that's why I really needed the auto body person to come in. I mean, Mr. Perry or Mr. Howard definitely damaged the door. But there's going to have to be a recalculation done because the right fender liner, the right wheel opening molding.
Yeah, I'm good.
From what I understand, the fender is part between the door and the front bumper, is my understanding of the fender. And there isn't any testimony regarding that. There isn't even any evidence regarding that. So when you take out 0.4 for labor for the right fender liner, right wheel opening molding, and a 1.0 for the paint.
We're going to be back.
What the right blackout tape rear is for, what that's for, because there's no.
All right, let's go to the spicy parts. So there's going to be some conflict between her story and his story as to whether or not he actually put this damage onto the vehicle.
Before this court regarding the rear door, there hasn't been any testimony regarding the rear door. You don't have anything from the
Or the fender.
From the what?
Or the fender as well.
Correct. Or the fender. And we don't have anything from the body shop people. They're not here to testify. And so the court's going to indicate restitution amount of $1,241.75.
Well, I want to file a motion because it's not fair. It's not fair at all. He kicked my door out of rage.
Ms. Pinkston, your testimony, as well as your statement that's in the police report, as well as the estimate that's put forth, shows the amount that was caused, the amount that was charged for the right passenger door. There wasn't any testimony about anything with the fender nor the rear door. This court cannot order restitution on the fender or the rear door without having any evidence that that was caused by Mr. Howard. Mr. Kazak subpoenaed the body shop person. They did not appear. I cannot assume what that person is going to say. I need to have it on the record for evidence. And that's what I need to base my ruling on.
Well, I want another court date because this is not fair. I have to come out of my pocket for some he intend doing maliciously, let knowing, I mean, this is preposterous. Just keep going through all this for nothing. He did it
Preposterous.
Ms. Pinkston, at this time, this is the court's ruling. If you have some other evidence that would suggest that the additional money is from Mr. Howard's actions, then you can certainly present it to the prosecutor.
And I will.
But at this point, what the court has, and I adjourned this from April, I believe, so that the person can be present and that person is not present. So therefore, the court's order is restitution in the amount of $1,241.75. Thank you very much. And we're going to be off the record.
You're gonna get yours.
Don't make threats. You're in court.
I ain't making threats. You are. Karma is something. Karma
Oh
is something else.
no!
Listen, that's not going to happen. You can remove yourself from the meeting. Do not make threats. Do not anything. That's not acceptable at all.
Tell him don't make threats and quit calling my damn phone.
Ma'am, you're in court. You need to have appropriate language.
Excuse me, Your Honor. Can I say something?
I have
We're not on the
voice
record.
message that you left. I have voice message that you left. So don't play with me.
Hold on, stop. Do not attack Mr. Howard.
Oh
Do not
no!
attack Mr. Howard. Yes, Mr. Howard, your attorney's still present. What would you like the court to know? We can go back to the record. Yes, Mr. Howard.
Yes, I would like to put a PPO out on her.
Well, this is not the
Oh!
jurisdiction for that. You
Yeah.
have to do that with third-
Yeah, you can't do it here. That's a completely separate matter.
Circuit Court.
I will be down to the court.
And I need to put one out on you. How about that?
Listen, man, I said not to address Mr. Howard.
Now, this is ridiculous. I amended the part that I played, but she never did.
You played a whole part. You maliciously picked mine down.
Oh!
Ms. Pinkston,
Why
that's
the fuck
enough.
you?
No,
Why
Mr.
the
Howard, that's it. Mr. Howard, Mr. Howard.
Shut up! Everybody needs to shut
I
up.
understand you pled guilty. I've assessed your restitution. If you feel the need to get a PPO, you need to take that to the third circuit court. The
Yes, I
district
will.
court does not have jurisdiction over that.
I will. Am I done here?
All right. You're all set. Yes, thank you. Off the
Thank you.
record.
Have a good day.
It's unfair. Karma is something. Karma is something. Karma is something. How about
Oh my god.
Oh my gosh, that's out.
No. The prosecutor's like, oh, god damn it. All right. All right, tomorrow we are going, we're going to go through the next 4, and we might actually do some trivia murder party. How about that? So we're going to go through the next 4 rounds of, the next 4 matches of round 1, I should say. Should be fun, should be exciting. So look forward to that. And I will see you guys next time. Thank you all for the super chats. Thank you for the subs. And thank you for all the likes. Check it out my Discord. Please do that on your way out. Hit that like button. And I will see you next time. Thanks, guys. Bye. Where's my kitty?